How are cases handled for a first, second, and third offense DUI? First offense DUIs are usually easier. For the most part, as a DUI lawyer, we try and portray them as aberrational or out of character. There's no presumption in a first offense case that a person has an alcohol problem, although there is in the court system what I call an alcohol bias. It has been a statistical reality that people with DUIs have a higher incidence of drinking problems than people who don't have DUIs. So if I said, for example, go get 1,000 people out there who have driver's licenses at random, and we'll call them Group A, and then go out and get another group of 1,000 people who have driver's licenses, but with one additional condition. They must either currently be facing or previously have had a DUI, and we'll call them Group B. No matter how you screen, you're going to find a higher incidence of alcohol problems with the Group B crowd than the Group A crowd. The courts know this, so anyone walking through the doors of a court with a DUI is seen as being in an at-risk situation. But it's much easier in a first offense case to reduce the preconception or the prejudice or bias that a person has an alcohol problem. We can temper that and show this to be an out-of-character incident. Jail in a first offense case is almost never on the table, so people shouldn't buy into fear-based marketing that your lawyer is going to keep you out of jail. You're not going to jail. So your lawyer's there to minimize consequences, not just keep you out of jail. Second offense DUIs are quite a bit different. There, the law does presume that you have an alcohol problem. It says that your relationship with alcohol, at a minimum, is risky to the general public. So you will be losing your license and you will be court-ordered into some kind of treatment. In that situation, it's very important to effectively deal with the problem. In other words, in my case, for example, I have a postgraduate education in addiction studies. I use that so that my client will get into the appropriate treatment. Left to their own devices, the court will always jam somebody into the most convenient, most well-known treatment program that they're familiar with, which may be a terrible fit for a person who works all day or has a busy schedule. So we'll work to make sure that they get the treatment that's required, but that also works for them. Third offense DUIs are felony cases. Here, all bets are off. By law, for example, a person convicted of a third offense must do 30 days in jail. That makes it imperative for me as the lawyer to try and reduce that felony down to a misdemeanor, and we can do that in many cases and spare a person not only from having to go to jail, but also from having a felony on their record. However, in all third offense cases, you really can't do much about the presumption that the person's relationship to alcohol has grown problematic, and treatment is not only necessary and inevitable, but also important. And in that case, it's not only a matter of getting the right kind of treatment for the person, but also treatment that will work and help ameliorate the consequences they're going to face in the court.